Hi, Dolly friends. This is Kitty,
And I'm Totty.
and welcome to Little Bottle Nursery. Our channel is dedicated to our love of dolls and creating fun and positivity in the doll hobby. So stick around and have some dolly fun. Hi, Dolly friends, and welcome back to our channel. If you're new here today, my name is Kitty, and with my daughter Totty, we are a doll collecting duo from Australia. Thank you for joining us today for this part 6 video. If you're new here today, this video series provides helpful information about manufacturing in China, and today's video will address foreign judgments in China. Specifically, this video will address some of the issues an individual may encounter when they have manufactured in China and decide to take legal action after their intellectual property has been infringed. This video will discuss foreign judgments and outline some of the pros and cons of filing a lawsuit in the individual's home country versus in China. If this is the first time you have visited our channel, we encourage you to check out our other videos in this series, and I will include the links in the description box below. Our previous videos provide a detailed explanation as to what prompted us to create this video series. So whilst I'm chatting about this topic, I'm also going to be changing some of the dollies in our nursery. Here are some of our Ashton Drake gallery dolls that you were introduced to in part 5. And I will continue to change their outfits in this video and do a big reveal at the end. So this is baby Aubrey. And I do have to apologise that if you hear some sort of gardening noise in the background, that's my husband doing his weekend gardening chores, so I do apologise for that. So let's get on with the topic. So some of you might be wondering, what on earth are foreign judgments? In law, foreign judgments are decisions that are made in a foreign court. What is important to understand is that not all foreign judgments are enforceable or automatically recognised in other jurisdictions, e.g. in other countries. In a nutshell, what this means is that certain laws in one country may not be recognised or enforceable in another. To give this some context, here is an example. An individual who is an Australian resident and manufactured their products in China decides to file an intellectual property infringement lawsuit in Australia against a foreign Chinese manufacturing company who copied their products. Say the individual is successful in winning their lawsuit in Australia. It's one thing to win their lawsuit in their home country, but it's an entirely different matter enforcing the Australian judgment in a foreign country like China. The reason why there can be problems with enforcement is because, as I said before, not all foreign judgments are recognised or enforceable in China. Because the main purpose of filing a lawsuit in court is to receive financial compensation, regardless of which country a lawsuit is won, enforcement is essentially the most crucial issue with litigation. And because the vast majority or all of the assets owned by a Chinese company is located in China, even if an individual has won their lawsuit in their home country, they will still need to have their judgment recognised and enforced in China. Under Chinese law, individuals cannot enforce a foreign judgment in China either through themselves or another foreign agency. A Chinese lawyer will need to assist in applying to the Chinese courts to have an individual's foreign judgment recognised, and then for the Chinese courts to decide whether to enforce the foreign judgment in China. The alternative option is when the individual, who is a foreigner, files a lawsuit in China. If an individual successfully wins, it is more convenient to enforce the judgment, as the Chinese Supreme People's Court is responsible for enforcement in China. They have the power to investigate the offending company's assets in China and implement compulsory measures to either freeze or seize assets for the individual's financial compensation. Since 2015, China has adopted a slightly more friendly approach towards the recognition of foreign judgments, with a handful of successful cases coming from countries including the US, Singapore and South Korea, where the Chinese courts have recognised foreign judgments. According to a survey by the China Justice Observer in May 2021, in 47 foreign judgment cases overseen by the Chinese courts, only 18 were enforced, reflecting a low 38% success rate. Earlier this year, China's Supreme People's Court published the 2021 conference summary of the Symposium on Foreign-Related Commercial and Maritime Trials of Courts nationwide. The conference addressed a number of core issues with regards to cross-border civil and commercial litigation and developed landmark judicial guidance which addresses changes for recognition and enforcement of foreign judgments in China. Decisions made at the conference were reached by judges nationwide attending the symposium to discuss how to adjudicate cases, which will be followed by all judges, noting that conference summaries are not legally binding but have a practical impact. The purpose of this conference summary was to express its views in recognition and enforcement of foreign judgments. There was a total of 17 articles reviewed, with detailed policy to provide guidance for the Chinese courts to review foreign judgments, including the application process. In basic terms, the 2021 conference summary determined that the Chinese courts will now have a more lenient standard for recognising and enforcing foreign judgments. The landmark decision makes substantial improvements in two areas. There's threshold and criteria, and enables a greater number of foreign judgments to be enforced in China. For example, the reciprocity test threshold has been significantly lowered for Chinese judges to examine applications for foreign judgment. This news initially created quite a buzz amongst legal professionals around the world. That was until it was revealed that although the 2021 conference summary will provide more leniency in regards to foreign and civil commercial judgments, it will not be applicable to the recognition and enforcement of relevant judgments for intellectual property, bankruptcy, unfair competition, and anti-monopoly cases due to geographical attributes. So intellectual property and the others that I mentioned remain excluded and may not be recognised or enforced in China, which is similar to the exclusion of such cases in the Hague Judgments Convention. So I'm just going to quickly show you now the document that I received that information from. Down the end of the document, I'm going to show you the original transcript, which is in Chinese, and then I'm going to show you how it's been translated into English. So there's two really good organisations online that have some wonderful information about what goes on in China through the courts. The first one is CJO Global, and they're China-related cross-border trade, risk management and debt collection organisation. They've got a blog. The blog is very, very good. I'll just click on that very quickly. And you can see, for example, here, they're right up to date with everything. So On the 19th of June, China dismisses application for enforcing a US judgment due to lack of finality. So there is a really good blog on that. And then the other company or organisation that's really worthwhile following online is the China Observer. And as you can see, the China Justice Observer, they are committed to presenting the Chinese judicial system. If you need to settle disputes in China, they will help you build reasonable expectations and develop effective strategies and solutions. So they actually have a really good document, and I've included it in the description box. What are the litigation pros and cons in China? They actually have a series on it. Very interesting documentation to read through. This is the document that I wanted to show you, the most important document. It's down in, the link to it is down in the description box below. It's the 2022 Breakthrough for Collecting Judgments in China. The latter part of the document, from pages 43 onwards, you will see the Chinese text of the 2021 conference summary. So there it is in Chinese, and then CJO Global has interpreted that in the earlier part of the document, which I'll go through now. So just doing a search on intellectual property, as you can see, the 2021 conference summary will not be applicable to the recognition and enforcement of the relevant judgments of bankruptcy, intellectual property, unfair competition, and anti-monopoly cases due to the geographical attributes. If you go down to the next section, it basically says the same thing. And the next section over here, the next section over here, it's even a clause. So 1.5 is the clause, exclusion of intellectual property, unfair competition, and anti-monopoly cases. These cases may not be recognised and enforced in China. This is similar to the exclusion of such cases in the Hague's Judgment Convention. So there you go, set out very, very clearly that intellectual property has not been included in the recent conference summary in China. So what does this mean now moving forward? Given that intellectual property has been excluded from the 2021 conference summary foreign judgments policy, it appears that there is no changes to the existing process for applying for foreign judgments in the Chinese courts. So let's go through what that process is. First, it's important to note that although China has signed the Convention on choice of court agreements, it has not been ratified. In addition, China has not acceded to the Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matter, so basically the Hague Judgments Convention. The Judgment Convention aims to obtain the recognition and enforcement of civil and commercial judgments internationally. However, there are limits to this convention, and excluded categories include intellectual property. To date, China has 39 countries where they have bilateral judicial assistance treaties, which 35 include judgment enforcement clauses. So given that intellectual property is excluded from the conference summary foreign judgments policy, the most appropriate legal framework in China that allows intellectual property infringement disputes to be resolved is through arbitration. And under Articles 281 and 282 of China's civil procedure law, there are two official ways to enforce foreign judgments in China: through a bilateral treaty or reciprocity. However, even with certain treaties, in the past, the Chinese courts have been well known for not recognising foreign laws or judgments if they believe it will conflict with the primary principles of Chinese law, or if it violates state sovereignty, security, social or public interest, noting that China is a communist country. It will be interesting to see in the future if the conference summary actually does produce positive changes in other areas of civil and commercial foreign judgments which are not intellectually property related, or if the Chinese courts will continue to resort to not recognising foreign laws or judgments due to conflicts with state sovereignty, etc. So, given that there's been no changes made to recognising foreign laws of judgments in China with regards to intellectual property, if an individual wins their lawsuit in Australia, in the Australian courts, and the product is considered being copied or illegal, it may not be recognised or enforced in the Chinese courts. So, look, it's really important for individuals to consult in advance with their legal team to confirm if the Chinese courts can enforce a foreign winning judgment case before commencing action outside of China. If the individual decides to sue in China, they're also going to need a legal expert to plan and manage a strategy for their cross-border dispute. Oh, look at baby Aubrey. She just looks so precious. Oh, she is such a little cute pie. Look at her and a Peter Rabbit. Okay, who's going to be next? So little baby Olivia joins us now. Isn't she gorgeous? So where was I? Look, at this point, it's worth noting that legal proceedings against intellectual property infringements are very costly. So individuals will first need to carefully consider all the pros and cons of taking legal action. An individual's accountant and law firm can assist with analysing their client's financial figures, including evaluating the value of their IP plus the return on investment and comparing it with the benefits gained in taking legal action against infringements, including at what level of action the individual can afford to take. Individuals will also need to consider if the amount of their claim can cover things like court costs, attorney fees, and the cost of potential notarization and authentication of documents if required from the individual's home country, and then weigh up whether all the stress and expense with pursuing legal action against infringements is financially beneficial to them. The Australian government, through IP Australia, has provided advice stating that one way of preparing for the cost of legal proceedings is to take out intellectual property insurance. If an individual decides that they do wish to proceed with legal action, their legal team should advise on the best course of action that will achieve the most beneficial financial outcome for them in the shortest possible time frame. Because that's the whole point of going to court, so that the individual can be appropriately reimbursed for the financial losses caused by infringements. An individual's legal team will also advise which jurisdiction is the most appropriate to file the lawsuit, either in China or in the individual's home country. So let's move on to discussing some of the specifics of an individual filing in their home country versus China. Let's start with suing through the Chinese courts. Civil proceedings in China follows the general rule that the burden of proof lies with the party filing the lawsuit. Therefore, individuals will have the responsibility of providing strong evidence in support of their allegations when filing a lawsuit in China. With a few exceptions, the other party generally does not have to comply with the individual's request and submit evidence against them. It is also a common practice in China for companies to transfer their property in anticipation of losing a lawsuit. Therefore, interim measures are crucial for the individual. Individuals filing a lawsuit in China can apply to the courts to implement measures against their Chinese manufacturers' property to prevent the property from being concealed, transferred, or sold. Interim measures are known as property preservation in China and can be applied for immediately after filing a lawsuit. The Chinese courts will only accept legal documents written in the Chinese language. Official certificate documentation that is issued after optionally registering intellectual property in China, including copyright, counts as suitable documentation to provide to the Chinese courts as evidence, as well as manufacturing contracts that have been written in dual languages, for example, in English and Chinese. Contracts written under Chinese law will also be favourably looked upon by the Chinese courts. If the Chinese courts rule in favour of the individual, the courts have the power to act swiftly in seizing the manufacturer's property for the purposes of compensating the individual. Super lawyer Dan Harris from Harris Bricken Law Firm, who has law firms in the US and China, has indicated that when his law firm has successfully won their cases in the Chinese courts, their clients have received their compensation very promptly, usually within a couple of weeks, which is really good. Anyway, now let's move on to suing in other countries. The discovery rule is generally followed for civil proceedings in other countries with common law, which means the individual filing the lawsuit can do so even if they do not have solid evidence. During discovery, they can force the defendant to give them evidence that can be used to help them build their own case. The rule allows the courts to more easily obtain evidence, but it also forces the litigant to disclose evidence against them also. If the individual files a lawsuit in their home country, for example, in Australia, they cannot apply to the Chinese courts for interim measures. In addition, the Chinese courts rarely enforce interim orders from foreign courts. Given that it's common practice in China for companies to conceal, transfer, or sell their property in anticipation of losing a lawsuit, this presents as a huge risk for individuals seeking financial compensation through their lawsuit. A representative from the offending Chinese manufacturing company will need to be seconded to attend court in Australia. So the Australian court will need to serve the defendant in China. This cross-border service will likely be governed by the 1965 Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, as China is a member of state of the convention. The service of documents is completed through China's Ministry of Justice, together with the cooperation from the Chinese Supreme People's Court and the local People's Court. It can take more than a year to second a representative from the offending Chinese manufacturing company, and this process has been known to fail from time to time. If the individual's home court rules in their favour, the individual will then need to engage with a Chinese legal professional to lodge their foreign judgment in the Chinese courts, as under Chinese law, foreigners cannot enforce a foreign judgment in China either through themselves or another foreign agency. The Australian government, through IP Australia, has provided quite a large volume of advice on this matter for Australian residents. For example, foreign judgments to be filed in the Chinese courts, they will need to be translated into the Chinese language and will need to be officially notarised by the Chinese Embassy in Australia and the Department of Foreign Affairs. This is a very costly and time-consuming exercise, often costing thousands of dollars and taking months to prepare. Given the recent 2021 conference summary policy stated that the Chinese courts will not recognise or enforce foreign judgments for intellectual property due to geographical attributes, it's worthwhile addressing that in the past, the Chinese courts have been quite fickle with recognising foreign judgments, even with those countries that they have bilateral agreements with. So there's a link in the description box below that contains a list of all the countries that have bilateral agreements with China, noting that Australia and the US do not have these bilateral agreements in place with China. And those countries who do not have a bilateral treaty in place rely on foreign judgments being recognised and enforced in a Chinese court based on reciprocity, which up until the recent changes in 2022 it's not been successful, with only a handful of foreign judgments being recognised in the Chinese courts. For example, the Chinese courts, they recognised only 2 US foreign judgments and zero from Australia. I have included a number of really useful links in the description box from CJO Global and the China Observer, and I encourage you to review the information so that you can get a clear understanding about why there has been such a low success rate of foreign judgments being recognised in China, as well as other useful data and information about the recent changes that the Chinese People's Court introduced in 2022. Another factor to consider when an individual files their lawsuit in their home country is the time it takes to resolve the matter. CJO Global has completed a study on the statistics and has published that on average, the length of proceedings takes 584 days for the recognition and enforcement of foreign judgments in China. The length of proceedings is divided into 2 stages. It takes, on average, 344 days for the Chinese courts to recognise the foreign judgment and another 240 days on average to enforce it. This duration is on top of the time taken in the courts in the individual's home country where the lawsuit was first filed, including organising a representative from the offending Chinese company to be seconded to attend court through, treaties and conventions, and having legal documents translated and novated by relevant authorities. It's a long process. So essentially, it could take years before a final decision is made and for the individual to receive their financial settlement if they win their lawsuit. This is a ridiculously long time for an individual to have their infringements acted upon. However, this is the harsh reality of choosing to have a lawsuit filed in the individual's home country. So these are some of the pros and cons of filing a lawsuit in your home country versus in China. I hope this has provided some clarity on why it is important for individuals to carefully select the most appropriate jurisdiction and what the benefits and disadvantages are for filing a lawsuit in your home country versus China. Seeking legal counsel to navigate this process is absolutely essential. It is interesting to note that both CJO Global, who are located in China, and super lawyer Dan Harris from Harris Bricken Law Firm, who has a law firm in the US and China, have both recommended that filing a lawsuit in China is the quickest and most effective way of pursuing infringements. Oh, look at precious Olivia. Isn't she gorgeous? She's my little second-hand Ashton Drake dolly that I got for a song online. She was so cheap. She came in such a bad state. The hair was horrendous. I've tried to fix it the best that I can, but it was completely matted. We actually have a video where I transformed this little girl and Noah as well, her brother. And I'll put the link in the description box if you're interested in checking it out. Okay, who are we on to next? So this is baby Noah, and he is one of two boy dolls that we have in our nursery. The other one's a reborn doll. So yeah, I love little Noah, my little second-hand boy. So where was I? Look, one obvious advantage of having an infringement lawsuit filed in an individual's home country is if intellectual property evidence requirements are not as high as foreign countries like China. With lower evidence requirements, the court in the individual's home country may rule in their favour, which is beneficial if the individual has not optionally registered their intellectual property in China and they have not put contracts in place with their factory when they have manufactured in China. Although filing in the individual's home country potentially has the benefit of winning their case, what is the point of filing, say, in the Australian jurisdiction if all it will do is add to litigation costs, wasting even more time not being able to initiate infringement takedowns, or even worse, if the foreign judgment is not eventually recognised or enforced by the Chinese courts, will reduce the likelihood of the individual ever collecting a financial settlement through liquidated damages. It's unfortunate, but many who are not familiar with how the Chinese court system operates will try to avoid the jurisdiction of the Chinese courts by choosing the jurisdiction in their home country, not realising that the Chinese courts can generally be the most quickest and cost-effective way in obtaining an acceptable result, especially when individuals have optionally registered their intellectual property in China and have the relevant dual language manufacturing agreements written under Chinese law. There are some really good articles online about this topic, and I have included some links in the description box that can help you get a better idea about the pros and cons of filing a lawsuit in China versus in your own home country. And I encourage viewers to really do your research on this topic, because the pros and cons are quite mind-blowing. Look, as we come to the conclusion of this part 6 video in this series, let's readdress some of the key points for the entire series. So, first of all, it is important that individuals who are considering manufacturing in China are proactive about protecting intellectual property. This includes actively engaging with legal and financial professionals to assist with protecting their brand and products on a global scale and ensuring legal measures are implemented to protect their work properly to reduce the risks of their work being copied. It is important for individuals who are considering manufacturing in foreign countries like China that they have a good understanding of how the laws operate within the foreign country that they have chosen to conduct their business operations in, and that they engage with suitably qualified professionals to assist them with navigating all the legal complexities and actively monitoring the market for copies of their products. Also important is for individuals to have legal contracts in place with their manufacturer to protect their intellectual property, so they are less likely to have someone from within their supply chain leak, copy or sell their product ideas either accidentally or purposely to third parties outside their supply chain. As I have discussed all throughout this video series. Registering intellectual property wherever possible provides ownership evidence, especially in foreign countries that have optional registration requirements, and manufacturing contracts together with intellectual property both play a key role in protecting an individual's brand and their products. Unfortunately, with no appropriate or effective legal measures such as optional IP registrations, due diligence, or strong manufacturing contracts in place to protect work, individuals will find it extremely difficult to enforce their intellectual property rights effectively in foreign countries that have high evidence requirements like China. They will also not be able to identify how their product design details have gotten into the hands of third parties and been copied, often outside their supply chain. The reality is that nobody is above the law in regards to negotiating business deals and manufacturing products in China. Intellectual property is a private property right, so individuals are responsible for registering, monitoring, and enforcing their IP through the appropriate channels. On the other hand, for those who have been proactive and have implemented the appropriate measures in place to protect their work, and it still gets copied, that is an unfortunate situation to sympathise with. Thankfully, those individuals, they have a much greater chance of successfully recovering their financial losses, and those matters will be resolved much faster than those who are not proactive about protecting their work. In conclusion, individuals and business entities planning to manufacture in China, they are responsible for building resilient strategies to protect their intellectual property. To do this, they need to be proactive about understanding their intellectual property vulnerabilities and potential losses. This information, it can be easily obtained by conducting basic research online, as I've shown you in this video series, and then obviously engaging with business and legal professionals to assist with developing a global intellectual property strategy. Registering intellectual property in China through their optional system and appropriate manufacturing agreements, so strong manufacturing agreements, are two such key components. Oh, look how precious they all look in their Peter Rabbit outfits. They're just darling. I'll have to do this at Easter time. This would be perfect for Easter. Mind you, we don't really have the cold weather in Australia at Easter to be putting them in all this long sleeve stuff. But anyway, so that's a wrap on the part 6 video. Thank you so much, Dolly friends, for being here today. If you've enjoyed today's video, please give it a like because it really helps us out. And if you're new here today, we would love it if you subscribed to our channel. So it's back to having some fun with our dollies. We have some exciting things to share with you coming up. There's going to be a couple of box openings and a shopping haul from one of our favourite baby clothing brands. We are looking forward to seeing you really soon, so stay tuned. Bye everyone. Bye for now. Bye.